Yes, welcome back to the No State Project. It's been a while since we got to do a live show here from the Fortified Compound in Mesa, Arizona. Glad to be with you here. Glad to be back live. And also streaming live, of course, on my YouTube channel, which, of course, is No State Project. If you want to call into the big show here today, it's in the show notes if you are watching on the YouTube stream. But it is 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. That'll get you in. It's not a toll-free call, unfortunately. But we try to get to everybody in order. So you can also reach me on Skype. I should probably open up and check that out on Skype there. It's Frank Rizzo 3. Frank Rizzo 3. So, okay, we'll get the Skype opened up. Big thing about some critics, I am using a different computer when I do the big show here and I stream it live, so I don't have my email opened up. So please don't think that because I'm not responding to email comments, especially from critics, that it's because I'm afraid of you. I just don't have it available, so it's best to get me on Skype or that there, the YouTube comments, which can be cancer-inducing. So, great! I'm here. I'm talking about using Skype, and it is installing the new update, which is absolutely awful. It is just dreadful. So anyway, we'll get to that. Couple things I want to get to. I'm not gonna, I guess it's kind of a thing with me. I've got a real issue about being accused of being afraid and not hearing dissent. There are a number of people that have been very vocal critics, just a few. Yeah, and I have the show that I do. What's the number again? It's in the show notes. All right. So, some that are very vocal about it, at least, behind the computer there when they're anonymous. They won't call a show and they have nothing but excuses that I'm an idiot, I won't treat them with respect, all I'll do is rant and rave, which is just not true. I mean, ICBM Catcher was on just a few weeks ago. That was, he was given his time to speak. As long as you're a professional and you don't talk over me, then we get along just fine. I'm not afraid to have my ideas challenged. I'm not afraid to have my work challenged. I do the show live. I don't have a staff. I have a friggin' mixing board that is driving me crazy. I don't screen the calls. What I was doing was, stupid comments and harassing comments in the YouTube chat, which is what YouTube chat is really for, apparently. So sometimes some people, when they're using racial word, I won't allow that to go through. It gets held back. If someone is just being, childish, or they're not adding to the conversation and they're distracting, or that they're just being insulting for the sake of being insulting, yeah. But you know what? I don't care. I'm going to pay more attention to the callers. I'm not going to moderate. So if there's somebody who's on YouTube who's crying that I'm not letting them, go for it. As long as you're not being harassing and stuff, I'll even be insulting. But this idea that I'm afraid of dissent and I hide, no, get a better criticism. Actually address the issues. And so one of the things I'll discuss today is, even though I've discussed this, I don't know. I've discussed this for maybe, I probably have recorded several hundred hours of me discussing how a voluntary society or certain things would be done in a voluntary society. I started doing radio, speaking almost exclusively about that. I talk about it practically every single show, depending on how many callers we got. So the idea that I don't actually discuss what we do in a voluntary society and is just laziness, or it's just a stupid criticism from people who don't bother to. Well, I can't say they don't bother listening to the show, because even though I'm described as an idiot, scammer, or a child, that they hang on every single word that I say, and that's why if I'm just ranting and raving and screaming like a child, why would you hang on every friggin' word that I say? That's the thing. There are YouTube channels that don't interest me because they just rant, they rave, and they act childish. So I don't watch them. I don't comment on every single video that they do. I just don't pay attention to people like that. But I think that's just a criticism. It's just but I will talk more, and like I do on practically every show. I think the specific one here was, and because I won't mention names doesn't mean that I'm afraid. I think it's better to address the argument like an adult, and it doesn't matter who is making the actual argument. So it has to do with, in a voluntary society without rulers, who would make and enforce the rules? Again, I don't know how many gigs of audio I have on my website, markstevens.net, where we talk about that. So, I guess some people would rather just say, oh, Mark's just afraid. Sure. Again, the number is 218-632-9399. The passcode is 2020 with the pound sign. If you want to set up an opportunity to speak to me on another live broadcast, I'll meet you there. You can have whoever you want to moderate. Okay? If I become childish, the moderator will stop it. So, okay. So, but I'll talk about that later in the broadcast. It was brought up today by a good friend who's called the show, Chris. So I wanted to address this again. Because I may not have laid this out as clearly as necessary. So the elements of a contract. So this goes to the idea that a written instrument, whether it's called the Constitution or the Arizona Revised Statutes, whatever, a written instrument, how many factual elements are necessary to be able to prove that this written instrument applies to somebody and creates obligations on them? And so, again, I don't use contract with the Constitution because, one, I don't think it even purports to be a contract. But as far as just any written instrument, what are the elements that would be necessary to prove that it applied to somebody and created obligations on them? And so there are four generally accepted, going across political boundaries, elements to whether a written instrument is in fact a contract or, say, an agreement binding on somebody and creating an obligation. So, one, you've got the offer. You got to have the offer. Two, you got to have a meeting of the minds. Very, very important. This is something that, when you talk about the Constitution, well, there's only 9 people on the face of the earth who can actually say what it means. So how could you have a meeting of the minds that applies to anybody when only 9 people at any one time knows, and can say what it means? So we are up against the break. So I will finish those 4 elements when I get back. So remember, the number, if you disagree with what I have to say, it's 218-632-9399. The passcode is 2020. And if I act like a jerk, there's a permanent record that you can prove. Because so far, you can't prove that I was disrespectful to anybody who called dissenting to the show. But we'll be back in just a moment. Yes, welcome back to the No State Project, streaming live, not only from LRN.FM, the Liberty Radio Network, from Keene, New Hampshire, also streaming on my YouTube channel. Hopefully we've got our caller line all straightened out now. You see. Okay, there we go. Everything is pretty good. So if you want to join me, if you think I'm afraid of you, my gosh, what did we get? What are the critics all 16 years old? Mark's just afraid. If you got some dissent, if you think there's evidence proven that the Constitution and these magical laws apply to people, if you've got actual proof, show. If you can show where my facts are wrong, where my logic is off, give us a call, 218-632-9399. The passcode is 2020 with the pound sign, and we'll hash it out. Because there's a permanent record, basically, practically, record of me dealing with critics and criticism on the show, and I don't think there's any examples of me being disrespectful. I bent over backwards for that lawyer by not using the mixer to mute him out when he was talking over me. And yeah, I got a little irritated, as anybody would when someone treats you like a piece of filth, like an idiot. So yeah, you get a little bit perturbed. But that wasn't because I wasn't the one being the jerk there. The lawyer was the one being the jerk. So I have people who call with dissent all the time, and the only reason why someone like the wit guy from Gilbert was because he was so abusive. It wasn't because of me. So these claims that I'm afraid, no, let's be grown-ups here. We're not in high school anymore. I'm not afraid of dissent. I'm not afraid to tackle an argument. If you want to address something I've mentioned on the show that wasn't true, 218-632-9399. The passcode is 2020. So, I have no time for these stupid excuses, which is why I generally don't read the YouTube comments. But to get back to what I was talking to before, the 4 elements of an agreement or contract for a written instrument to actually be applicable. At least to start, we're talking about actual proof here, not just saying it is. Hey, but somebody from 1775 said so, or a bunch of lawyers from 1869 said so. I mean actual proof, because going to someone saying, well, someone said it was true, doesn't make something true, okay? Just that applies to me. For some reason, the critics understand that applies to me, but it doesn't apply to their authority figures. Okay. Well, Mark, no lawyer has ever agreed with you. Oh, really? Because the truth requires consensus. Okay, so we talked about an offer, or if you're outside of Long Island, an offer. A meeting of the minds. This is critical. That you have to be agreeing to the same thing. The same thing. 3 would be a freely made agreement. And this is one of the things I talk about, where all this noise about the driver's license being a contract, or, that the courts are trying to contract with you, the sovereign citizen or sovereign freeman on the land type of stuff. No. Because with government, it's not freely made. You either do it or you go to prison. So you have to have a freely made agreement after a meeting of the minds. You are both agreeing to the same thing. And then you have to have a valuable consideration. So if you have the first 3, but there's been no, at least one, one side doesn't provide the valuable consideration, then it's not necessarily a contract. So there you have it. So this is why when we look at something like that, why even if the Constitution, the text itself, looked to be a contract, it couldn't possibly be a contract because there's no freely made agreement. Well, but Mark, you idiot, the people voted for it. Well, see, this is another point of contention where people, well, why do you keep going back to 1775 or 1776? Because that's when the first constitutions were written. 1775 or so, the United States, the New York government adopted the Declaration of Independence as part of the initial Constitution. So That's why I do that. It's called logic. You go back to the beginning, because the federal Constitution was it was supposed to be part of the so-called state governments were the ones that were calling for that to be done. So, did anybody have a choice with the original 12 constitutions? No. Did anybody have a choice as to whether there was going to be a government or not? Well, the people that were supposed to live under it didn't. It was either that or they get shot when they had their estates taken or burnt to the ground. So that's why I go back to that. And as far as the federal government too, did anybody have a choice? Did anybody have a choice where there was a government? No, you don't. So the Constitution in no shape or form could be considered a contract. There was no freely given agreement, and there's no meaning in the minds. So, yeah, I'm glad I went through that, and I'll real quick, I went through this recently also, but it always bears repeating, okay? A justiciable case or controversy or a valid cause of action. How does the court get subject matter jurisdiction? Okay, how does somebody have standing to complain and have a court have jurisdiction over their complaint? There are 3 basic elements over here which come nicely from what we've been talking about as far as the Constitution being applicable. Being, that it's contractual. Now, I do want to throw out that the Supreme Court has come out and ruled, at least in dicta, that, and I think it was John Marshall that was saying that the relationship of the government to the citizen is contractual in nature. Of course, there's no evidence to support that, but hey, judges are authoritized. They don't have to back up their decision. In fact, there's someone right now that'll say judges don't have to give any reason for their decisions. They could just make a ruling. They don't have to answer to anybody. They don't have to give you any reason for the decision. I say that's wrong. That's dishonest. Just because someone dons a black robe and there's a literal army of people forcing strangers to give him money and pay his salary and his pension, doesn't mean that good faith suddenly is out the window. I guess it does. And that's why they feel, and their minions feel, that they don't have to give, that judges are these exalted, wonderful, honorable people that are exempt from all the principles of logic and due process and fairness, that they can make things up and they don't have to have any basis for whatsoever. Well, Mark, they don't have to tell you. All right. Again, if you dissent with what I'm saying, what I've said on previous shows, 218-632-9399. Passcode is 2020. And we'll hash it out in real time. Till then, we'll be back in just a moment, so don't go away. Yes, welcome back to the No State Project. You're tuned in on LRN.FM, the Liberty Radio Network, and also streaming live on my YouTube channel. Of course, it's No State Project. And you can join me. The number, of course, 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign. And also on Skype at Frank Rizzo 3, which I probably should be checking that a little more often, but I'm glad to be with you back here. And yes, the Frank Rizzo is a Jerky Boys reference. So he was the former mayor and police chief in Philadelphia. How to talk about a hothead. Wow, this is a... there's actually video of him threatening to beat up a reporter, which is hilarious. Because that's the mindset of politicians. Just use force to get what you want. Oh, people may not pay? Force them. It's okay. And don't worry about it, because we'll pay lawyers called judges, and they'll have an army of people that part of their support system, and they'll support them. That if anybody starts to talk about or question their decisions, then they'll go on YouTube and start shouting people down that judges don't know. No, judges are a special class. They're a special class. They can make decisions that affect thousands or even millions of people. They don't have to have any grounds whatsoever for that decision. So It's astounding to me. Just the things that you'll hear, the arguments or the criticisms that people will level, and to go and accuse me of certain things. But I want to address something without addressing the name of the individual who I'm talking about. But I tend to stay off of Facebook. I use it primarily just to promote the show. Again, the reason why I stay off of Facebook is not because I'm afraid of dissent. It's because it's such a toxic environment. Why don't I respond to most comments on YouTube? Because most of them aren't worthy of response. So most people know that, yeah, Facebook and a lot of social media is very toxic areas, and I just don't engage there. But I do it in real time here, so at least it's not, there's a record. People, it's there in the moment. They either put up or shut up, or, and if they accuse me of being unprofessional, there's a record that the whole world can see. So I'd rather address the argument and not give anybody any undue attention or cause some kind of drama where they'll start doing videos, not about the argument, but about me. There's a well-known anarchist, and for whatever reason, he's very prolific on Facebook. I mean, he posts constantly. I mean, it's almost every time I open up Facebook to do a post about the show, because it'll be the first post. It'll be the first post in the feed, and so I'll skim it, and I'm amazed at just how ridiculous. I want to just address something. Why did I leave? I didn't leave Discord. I just don't go on the same server with him, and he's got a history. Go back and watch that video or listen and see how unprofessional he was. And if you think that interrupting somebody literally every time he goes to answer is professional, then I got nothing to say. I'm not going to deal with people who were given a chance to be professional and every step of the way refused to extend me even a little bit of courtesy. Even a little bit of courtesy. So that's why I don't deal with people who are unprofessional and discourteous. And by interrupting me on almost every single time I went to answer him shows to me not only a lack of respect, but so condescendingly friggin' arrogant that he's not worthy of my time. I'll address arguments. I don't need to address people who are unprofessional. I have no problem addressing arguments. Okay? That's what adults do. I gave him every single chance. I should have cut him from the show instead of just using the mute button. But if anyone thinks that I shouldn't use the mute button when somebody is talking incessantly over you and absolutely won't shut up long enough for you to actually answer his question or address his argument, that's what you got to do. So you can spin it any way you want. The video is up. The audio is there. Everybody can see and hear for themselves. I wasn't the unprofessional one. I was only unprofessional to my audience because I didn't cut him off the show after the second or third time that he interrupted me. So, no, I'm not going to sit here and dedicate my whole show to somebody who couldn't shut up long enough. And yeah, he spoke over me. He even apologized. So that's that. Again, somebody wants to call 218-632-9399. But it is this self-proclaimed anarchist who who has quite a following, and again, I want to address the argument, and I don't mention the name or anything like that because I don't want it coming back that, oh, Mark Stevens is a socialist, Mark Stevens is a communist. All I'm doing here, and I'm not either one, all I want to do is point out that some people who have massive followings put things on social media and don't know what they're talking about. And this particular one loves to rail against socialists and communists. And in this last one, I shouldn't even waste the time doing this. But it had to do with the making the assumption that communists, the actual communists, I'm talking about the actual communist philosophy and socialist philosophy, that actually, that they want massive government. And if you look at the actual philosophy, Socialism is a means to an end to get to a voluntary stateless society. Communism differs from socialism in that it advocates violent revolution, whereas socialism generally does not. And the socialism, the end game of socialism, is the same thing for an anarchist in that it's a voluntary society without rulers. And it's mind-boggling to me, the echo chamber that this particular anarchist lives in, that nobody points out. Again, I don't point it out because I'm not going to engage this individual or anybody on Facebook, okay? But nobody points out, so don't you know that socialism's end game is a governmentless society? That communism, that it is to get to a voluntary society, a society without government? They just pile on and make fun of perceived, socialists. So, yeah. It's some. So that's why, again, another reason why because if I had posted something like that on Facebook, and I've had it here talking about what socialism actually is, where people then on YouTube and on the comments on my website will start thinking that I'm a communist. No, I'm not. I'm not a communist. I don't advocate violent revolution, and I certainly don't want. As far as socialism, I wouldn't want to see it beyond basic services that government provides now. I don't see any problem with commonly known or community-owned services, which gets to, again, what I've spoken about so many times here on the show. And I guess it's just something you have to deal with internet trolls. Even when you squarely address exactly what they're saying, they'll just come out with something else. Oh, he's avoiding it. So, anyway, before, someone's saying Chief Judge Michael B. Thornton in the tax court. I have had experience with Michael Thornton. In fact, I've done videos where I have some pictures of him. If you want some solid evidence of how dishonest Michael B. Thornton is, go back and look up in my videos and you can see. And what Michael B. Thornton does is not any different than any other tax court judge that I've experienced. And we'll discuss this when we get back. And that has to do with the presumption of correctness. Yeah. They don't like stripping IRS agents of that. But we'll talk about that when we get back. My name is Mark Stevens. The number is 218-632-9399. 218-632-9399. The passcode is 2020 with the pound sign. Yes, welcome back to the No State Project here on LRN.FM, the Liberty Radio Network. Yeah, Paul saying, Mark, I got the judge to admit he has no evidence and he still proceeded with the trial. Of course, they make it because they're criminals. They're criminals. But I was saying about the presumption of correctness before the break. I can document, and I have documented this on my website. You got to go back a number of years, where Michael B. Thornton, even after IRS General District Counsel admitting several times in writing to not having any evidence to support the IRS's claim. None. Zero. I'm not talking jurisdiction, just jurisdiction. I'm talking no evidence, period, of any kind of liability or obligation at all. They admitted this. The lawyer's name is Rakin. And despite that, and despite the law being very clear that that to have a presumption of correctness, there has to be proof. There has to be evidence. There has to be facts. Helving versus Taylor, that if it's held that it's arbitrary, then that's sufficient to wipe it out, to strip them of their presumption of correctness. Not a single tax court judge we have ever seen, even with documented proof, admissions from the IRS counsel, not one single judge has ever complied with the law and stripped them of their presumption of correctness. It doesn't mean that the IRS ultimately loses. It just means the burden shifts back to them. But they don't do that. It's the same. I was talking to Chris this morning regarding the anti-injunctive tax acts. 100% of the time, judges in California and the federal courts, every single time, without exception, will not even acknowledge the law. They won't acknowledge that there is a narrow exception to the Anti-Injunctive Tax Act. The Supreme Court has laid it out. State Supreme Courts have. I've cited it here on the show. It's the Duke Majan case in California is one of them, Western Oil. So it's there. It's there. And they ignore it. And yes, even though in California, judicial notice of the law is mandatory. I think it's Section 455 of the Evidence Code. Mandatory. No discretion. Mandatory. Not one time we have brought a petition for writ of mandamus. Not once have they even accepted jurisdiction. And you know what they do? They say, you didn't show an abuse of discretion. You don't have to on a petition for writ of mandamus. You just have to show that they didn't comply with a mandatory function of the office. Judicial notice is mandatory under Section 455. We showed them the law. They said, Abafongo. They don't care. That is systemic bias that you can show that the system itself, the judges, no matter where they are, absolutely refusing to even acknowledge their law. This is not even saying, well, is this case within this exception? They won't. Why do you think I had 3 monkeys on the back of Adventures in Legal Land? That's one of the primary reasons that I came up with that. They won't acknowledge it. And the reason why they don't acknowledge it is because they're dishonest. So these people that put so much reverence into what these judges say and do, don't you think it's a little misplaced when they're so damn biased and they're so dishonest? Please. Show me the judge, man. Well, you know what? I'm going to be posting Monday or Tuesday a video where somebody went through, and I helped him through this. He's got a bunch of other tickets that were thrown out. He didn't get the ticket thrown out because of his defense before the trial. He got the ticket. He got an acquittal from a judge based on his actual defense. Now, I know. I know. Mark, how can you say his defense had anything to do with it? He went through trial. Oh, but it's still, I know that we're going to have 2 or 3 people who are so vocal, say, it doesn't, just because he went and did a cross-examination, and just because he had a trial, and just because he defended himself, doesn't mean the judge acquitted him based on anything it had to do with him. The judge was just teaching the prosecutor a lesson. Because you can't ever, see, that's part of the narrative. They can never accept that somebody who I work with went and had any success based on what I helped him with. So even though he went through a trial in New York and was acquitted, it's the same thing when we got Rebecca here in Chandler, Arizona. She had a full jury acquittal on one of the 2 charges. I had nothing to do with her defense. Nothing. Nothing at all. And the facts that they have to back up that statement? None. They can't even say it's like I do. They can't even say this is what you're going to get from these political people. Even self-proclaimed anarchists, apparently. They can't even say that my position or my argument is plausible. What does that tell you about about someone's honesty? It's not even plausible. So the facts, there's one explanation only. There's no other plausible explanation. Okay? Because they have all the context, not the person who's reporting it to me. So, but I'll get that posted. I do have the documentary proof. And we'll get that posted, and I'll have some of the details that were reported to me in the email, so you have an idea of what happened. Yes, he did cross-examine a police officer. The police officer made some pretty nice admissions, and basically not knowing what he was doing, not having any facts, and so he was acquitted. I will at least say, and I'll put in the video, there's other plausible explanations. I think this is the strongest one. I think this is what the evidence points. But always know, especially in situations like this, when we're talking about other people, anyone who slams the door shut on any other possible plausible explanation to explain the facts is probably being dishonest with you. and when given the opportunity to call and confront me live on the show for several years, refuses because he thinks that I control a live broadcast, they can't back up their claim. I'm the one who's afraid that I'm sitting here on the show going live, taking calls without screening. So, anyway, enough of that crap. Let's get to area code. We have area code 818. What's your name and where in California are you calling from?
This is Paul, and it's a California number, but I'm slightly farther east than that.
Paul, Paisan.
Good to talk to you, Mark.
Buongiorno, Paisan. What can I do for you today?
Oh, well, I just thought, hey, for once, I haven't forgotten to tune in while you were still on the air. So I thought I'd give you a call and catch up to what's going on.
All right,
looking forward to, are you going to be going down to Acapulco next month?
No, I can't travel right now out, like that. And I've been invited by a few people the last few years, and I can't do that.
All right. Well, we were there last year, and we're going again this year. We'll give you a report. It was a lot of fun.
Yeah, I've heard it. It's a good time and whatnot. I make my travel. I've probably mentioned I travel back and forth to Southern California every 2 weeks. I'll take care of family, so it's not. I'm not in a position right now where my wife and I are comfortable traveling outside the usual routine.
I understand. Yeah, I'm just enjoying the show. I don't have any particular legal issues to hash out right now, but hopefully that remains the case. Involved with these criminals.
I certainly hope that remains the case, although we're a little bit nearer to each other now. So, but still, I'd rather unless you're doing something as an activist, then I hope you're right. No issues that way. And we'll have to get together on Monday.
No, yes, absolutely. All right. Well, just want to let you know I'm listening in and look forward to getting together sometime and hopping a few stories.
Yeah, I appreciate that.
Keep up the good work. And
we'll talk after the show. We'll set something up for Monday.
Great. Excellent.
All right. Appreciate the call, Paul, formerly from California. Right. We're up against the break, so we got to let you go. But the line is free now. We had a number of callers, but hopefully they get back. And they call 218-632-9399, 218-632-9399. The passcode is 2020. It is not a toll-free number, but we'll get you as soon as we can. And we'll be back in just a few moments, so don't go anywhere. Welcome back. Second of 3 hours of Anarchy Radio right here on the Liberty Radio Network, LRN.FM, and streaming live, of course, from my fortified compound in Mesa, Arizona, which I describe as a fortified compound instead of a house, because that's what the lying media did and how they try to smear people to keep, because the one thing about media, they are pro-government. And so there's no choice, there's no inaccuracy there. So what they did years ago was they painted the Browns up in New Hampshire as, the tax, there was a tax prosecution. And they didn't live because they were, against government abuse and governments in general. They didn't live in a house; they lived in a compound, a fortified compound, and they didn't have a basement; they had a dungeon. So that's why. And we talk about anarchy being no rule is not no rules. And I'll get to what do we do in a society with no rulers? Who makes the rules and enforces them? Something I've spoken about 100 times. Just I do all the time. So we'll talk about it again. Some legal stuff here. Friend up in Alaska is asking, if jurisdiction can be challenged at any time, how does one get around having an attorney imposed that won't raise the issue? Well, this is something we've spoken about. It's a real problem because they are muzzling you. Criticism could be, the attorney doesn't have to raise your stupid arguments. Just because you don't think that there's jurisdiction doesn't mean the attorney agrees and has to do that. Well, jurisdiction has to be proven. There has to be facts. This is not up for debate. Again, I'll quote our friend DeJarnes. I keep mispronouncing that. Up in New Hampshire, jurisdiction is a pure issue of law and requires no evidence to prove. All the prosecution has to do is show that you were physically in New Hampshire. Whether you were physically in New Hampshire is not an issue of law. It's fact. It has to be facts. And being that, and this comes into, something somebody was saying or asking about, asking an attorney about jurisdiction is proven simply because you're here. And the problem with that is, and the problem is not with the argument. The problem is with the inherent bias that lawyers have. Lawyers are they are officers and counselors of the court. They are literally government. They may not pay. Now, a lot of them, like Mark Victor, are not paid by the government, but they are a part of the government. They are officers and counselors of the court. They take an oath of office. Yes, Mark says he took. Well, I'm not going to get into that. But some lawyers claim to not use their name. But the fact is, they're, whatever they say in court, get the G. Whatever they may say in court is not necessarily relevant because they have to sign it. They have an oath of office. It is not up for rational dispute that lawyers are officers and counselors of the court, and the court being a part of the government, the judicial branch. So they have inherent biases. Okay? So it's not that the argument or that the challenge is irrational. It's because the lawyers don't want to do that. And so I want to get to this, but let me finish this, that Back is asking, Jay Back. If that's the case, you're pretty much screwed. Now, because it comes down to the judge, like I've said before, the judge is the undisputed boss of the court. The attorneys don't get paid by him, but when they're in court, they are under his control. And if that judge forces that lawyer on you, they may get another lawyer from the public defender's office or another private attorney. Yeah. But if they don't want to raise that issue, if they don't want to challenge the very foundation of the prosecution's case, that's not because the argument is not sound. It's not an effective defense. Because I got to tell you, anytime you got a prosecutor saying, I don't have to prove this, again, it's not that the argument is bad. It's the attorney. This is why I say, it's 3 things that I ask these attorneys, and they always contradict themselves. Ask the attorneys this when they go through this. Don't take what they say at face value. Challenge them. Just because an attorney says X, Y, Z doesn't mean it's true. Just like if I say it doesn't mean it's true. Challenge them. Make them prove it. So I go through 3 questions when we're talking to attorneys about this. When we defend ourselves, shouldn't we challenge the prosecution's claims? Yep. Ain't gotta go to law school to know that. Good. 2, should we give the prosecution's claims any free passes? And they'll say no. So you should challenge all the prosecutor's claims. Yep. 3, and I'm going to challenge the prosecution's assertion that the laws apply and I violated them. You can't do that. Which contradicts question number 2. So they are the ones contradicting themselves. They're the ones who want to give them a free pass. And yet there'll be some that will defend that. And the best that I've ever heard is this. I wrote about it in Government Indicted. You'll piss off the judge. See, it's not because it's not an effective defense. It's not because it's illogical, because it's not. Because you'll piss off the judge. Oh, well, okay. I wasn't born when Kennedy was shot. How can I be accused of that? Isn't it? I mean, I wasn't born for years after Kennedy was shot. I couldn't possibly have been the guy that killed Kennedy. Isn't that something that we should bring up? No. You don't want to piss off that judge. No. We're not going to do that. We're not going to piss off the judge. And if you argue you weren't born for so many years after Kennedy was shot, no, you're just going to anger the judge. So that's what you should do. You should go to somebody who's going to base his defense on you, the defense of you. He should base it off of the principle of, well, will it piss the judge off or not? Imagine your life hanging in the balance, and the lawyer's not going to make an argument because it might piss off the judge. Not whether the argument is true, not whether it's effective. Because remember, they're the ones that will contradict themselves when you ask those three questions. Ask them point blank those three questions. They will contradict number two every single time. No, you can't challenge that. You just said we shouldn't give them a free pass. Again, this is not every lawyer has said this to me. Everyone I've spoken to about this has said that. You don't want to piss off the judge. You're just going to tick them off. And I'm not going to... All right, we'll get to the calls in just a second, so just hang tight, guys. I don't want to take a call so close to a break. So and another thing, someone's asking if I'm Italian. I am not Italian. I got nothing against my paisan, my Italiano paisan, but I'm not Italian. I am Sicilian, and they are not the same thing. Vastly different influences with the Sicilians. And my family is from a little town outside of Palermo named Carini. And so if there's anybody out there who's from grandparents are from Carini, we might be paisan. We might be Goombas. All right, I will get back to the jurisdiction issue. We'll get to our calls on the other side. If you want to join us, it's 218-632-9399, 218-632-9399. The passcode is 2020 with that there pound sign. And we will be back with your calls in just a moment. Don't go away. For YouTube guys, we are on a break. Yes, welcome back. The No State Project live for January 26th, 2019 over there. And real quick, to finish, and we'll talk more about this after the calls. Somebody's saying that he asked an attorney about the laws applying, and he said they have jurisdiction simply because you're here. And if there are some statements that just beg for a follow-up question. And this is just one of them, simply because you're here. Why would anybody allow somebody to make a statement like that? And I imagine you're asking them because they have advanced university degrees, and you think that they, are an expert on this since that's their job to be. Why just accept it? Explain why that's true. Isn't the Constitution a written instrument? Yes. Well, tell me exactly how it applies to me just because I'm physically here. This is where it helps to know the basic logical fallacies, because they're not going to be able to tell you. I've had attorneys, seasoned prosecutors that are on markstevens.net. You can go to the Call of Shames, and they'll say they just do. They just do. So don't take what I say. I invite people to come on and call me out. We should not just accept something just because someone who seems to be an authority on it says so. Jurisdiction simply because you're here. Yeah. Because that's how warrants work? That's how a subpoena works? So if I'm not here, if I'm in France? No, because jurisdiction's based on a relationship at the federal level, at least at the federal level. So jurisdiction simply because you're here. Probe. Ask questions why they think that that's true. What facts actually support that claim? Don't just repeat your claim. Jeez. You know, I don't understand how a computer monitor works. If someone just said, it just does, I wouldn't accept it. Because I can go to somebody who knows what they're talking about. If that's all they could say, then chances are they don't know. Hey, we're going to go. He's been on the show before. We've got Chris in North Carolina. Welcome back to the show.
Yes, thank you, Mark.
Good news?
I'm just giving you an update. I sent in the discovery request and Brady request and still haven't gotten a response yet. I sent you an audio recording of the prosecution, and I asked them, about jurisdiction. Oh, that's legal advice. That's legal advice.
Yeah, that's something I'm gonna have to. You're gonna have to give me a reminder. I'm gonna need to hear. I'd like to hear that. Did he know he was being recorded?
No.
All right, so not something that we can post, but
Oh, okay.
Yeah, unless you're in Arizona, it's a prosecutor. Even if it's a one-party consent, I wouldn't do it because you don't know what else this guy can charge you with. Not worth it. I'll take your word on it. That's what he said, and I'll go listen to it.
Right.
So what did you say in response to this really stupid statement from him?
No, I just let him go because I knew, I wasn't going to get anywhere.
You let him go?
Yeah, I just hung up because I knew he wasn't going to get anywhere. It was not legal advice, or that's legal advice. It's legal advice. He told me that as soon as I got on the phone, I said, I talked to you about my case. Oh, I can't give you no legal advice.
Okay. Now, I understand him saying at that point, because he just doesn't want to talk to you. When you asked him for the discovery, he used the same line that he can't give you legal advice.
Correct.
See, this falls under the umbrella where someone came on the show, a lawyer, who may try to say the same thing, saying that advice in a legal sense does not just mean suggestion. And actually it does. When you're asking for evidence from the prosecutor, and the prosecutor is obligated by due process and principles of fairness to give you that disclosure, it is at the least bad faith for him to say legal advice. This is like, so imagine this for a second, everybody. Police officer pulls you over. And this is just for discussion. License and registration, son. And you say, I can't give you legal advice. What do you think the cop is going to do?
Flip his wig, probably.
The hand is going to go to his gun, and he's going to say one more. He's not even going to address this stupid thing that just came out of your mouth. Imagine being on the stand. Or let's say the judge is saying, sir, how do you plead? Guilty or not guilty or no contest? And you say, I can't give you legal advice there, tough guy. Ha ha. I mean, come on. The thing is, you can't let these things go. It can't, I heard that song like 1,000 times. Let it go. You can't let him go with that. You have to at least follow it up. Yeah, you're probably not going to get anywhere because he's telling you when he says legal advice, he is saying, I am not going to treat you as an adult. I am not going to be professional with you in any way, sir. I want you to hang up the phone now. That's what that means. I am not going to engage you. So you have to say, excuse me. How is asking for evidence that you're supposed to provide legal advice? Or you could just dumb it down and say, excuse me, aren't you obligated to provide disclosure?
Right.
This is, look, what I would do is file the motion. Contact me off air. I'll get you the motion to dismiss for prosecutorial misconduct. Put in his
All right.
statements from the phone call into that motion.
Okay.
Oh my gosh. I'm almost at the limit of how much stupidity I can tolerate in one day.
Yeah, I know.
Wow. But it's good that you're letting us know this, and I do appreciate that. I'm not saying I'm sick of you. It's just that's such a stupid thing to have to process. But for everyone listening, we cannot take these statements and just let it go. So if you speak to him again, don't let him off the hook with these stupid statements. Don't make it. If all you're doing is making his job more difficult, maybe he's inclined not to prosecute you then. But it's worth it. Don't let him get off. Okay, so we talked about that. So is there anything else?
No, I contacted a lawyer and talked to a lawyer about it, and he just like talked over me and just explained it all away. I mean, I went so far as to email him.
Well, hold on 1 second. We're up against the break, so we'll come back to you speaking with the lawyer. My name's Mark Stevens. Oh my gosh, I feel so bad for Chris. Legal advice, asking for your proof. Okay, we'll address that in the next segment. So don't go anywhere. We'll be back with Chris in North Carolina, and we are on a break for those on YouTube. My boy, Chris Case on that guitar. Double Bucci, which I still have to get that posted here on YouTube, the whole CD, so you guys can hear all that. But if you are down in Key West in the Duval Street area, you want to see some good blues, you heard it. Chris Case, he's the man. Real quick, we're gonna bring Chris back, and I want to read here legal advice. Legal advice is the giving of a professional or formal opinion regarding the substance or procedure of the law in relation to a particular factual situation. Here's the important part. The provision of legal advice will often involve analyzing a set of facts and advising a person to take a specific course of action based on the applicable law. Now, I don't know in what universe somebody would think that asking the prosecutor to provide his disclosure is asking the prosecutor for legal advice. So I just had to I had to bring it out again. So you had called a lawyer about this?
Yes.
How did this go?
Not good. I mean, I edited the paperwork I got from you for the motion to strike and dismiss. And I had emailed it to him with all my information, none of yours or, anything like that. I had edited the whole thing. And he just talked over me and explained it all away. And like with the jurisdiction, he said, well, simply because you're here. And like, I couldn't get through to him, you know what I'm saying? And I knew he wasn't going to do that anyway. So.
I'm sorry, Chris, are you the one that posted that earlier on the chat?
Yes.
Oh, okay. So I'm sorry. There's a lot in the chat there, so it kind of gets okay. Right. So this particular, I was addressing what you had put up there, and so again, you just let this attorney. You didn't pay this guy, did you?
No.
Okay, so it's not that bad.
Right.
Wow. Yeah, we can't just let this go.
I was thinking, like you said, he knows, he paid for that so-called education and like that, and then him being a lawyer, they would take him a little more seriously, so I checked him to see where he was at, and of course he wasn't going for it.
So remember, if you ever speak, you or somebody else listening, if you're talking and interested in hiring a lawyer, ask him those 3 questions. Shouldn't we zealously challenge or collaterally attack the prosecution's claims against me? Yep. 2, should we give the prosecution's claims any free passes? Are there some that we just shouldn't attack when we defend ourselves? Nope. And then, since the prosecutor is claiming that the laws apply and I violated them, shouldn't I be zealously attacking the claim that the laws apply? And
Right.
when he contradicts himself, you know who the problem is. It's not your argument. It's not you. It's not your defense. It's
Right.
him. He has the
Right.
issue. There's no basis in logic or reason. He has a personal issue. So none of his education it has nothing to do with his education. It has everything to do with his perceived what's perceived will happen in court, which 9 out of 10 attorneys have told me it'll just piss the judge off.
Yeah, the way he was programmed.
Yeah, they accept that. They don't go to law school and are taught to challenge that. I think the only time lawyers would look at that, or a bureaucrat would ever look at that, is if a foreign court is charging them. So you look at what that lunatic, that mass murdering Milosevic did from Yugoslavia. He challenged the jurisdiction of the World Court, the World Criminal Court. And I think Saddam Hussein did the same thing. This isn't a legitimate body, so they're challenging the application and of the laws and the jurisdiction of that court to do that. So
right.
maybe the blinders are off there. Oh, but when it's domestic, no, you got to accept that. And that's the thing. I don't think that that's the right thing to do, and that's why we challenge it, and we've been effective doing that. Because why else on cross-examination, when you ask for the police officer's facts to back up his claim that the laws apply and you violate, and specifically that the laws applied, they won't let him answer that question. Why? Because it's like the cop said up in Canada with Jermaine. I don't know. They're not basing it on any facts. They have no personal knowledge. They're not qualified to testify. So,
right.
So hopefully,
well, I asked him.
Sorry.
I asked him how he would handle it then, and he proceeded to tell me that he would make a motion to suppress the evidence, pay him $500, and he would take care of the court costs. But I would have a $190 fine. I'd have to go to a drug assessment that I would have to pay $100 for, and do 24 hours community service.
So
he wanted to throw me under the proverbial bus, really.
He wanted to make a deal. He wanted to make a deal.
Yeah.
But that's what attorneys do 95% of the time.
Right.
State and federal.
Oh, but I've been doing this for a long time. I got a lot of experience.
So if you're going to move to suppress the evidence, why not take it to trial? Or unless he was saying, well, if we move to suppress the evidence and it's not granted, then you should make a deal and this is what it should be.
Right. And he wanted to charge me $700 to go to trial.
What was his defense going to be if you took it to trial? What was his theory?
He didn't say.
So he wanted you to pay. Okay, well, I can see that. I can see. I'm not going to fault him necessarily for that.
Right.
Well, at least he's not charging you $5,000. You know.
Right. Yeah.
Well,
yeah.
I would. Well, look. Somebody doesn't, it's and your choice. If we're the ones under attack, it's always our choice whether to have an attorney or not. So that's a choice up to you. I don't know how much time you're looking at. It doesn't sound like this is something that is a lot of time. It sounds like it's a minor thing based on the deal he's saying he can do. I personally, what I would do is I would file the motion to dismiss for prosecutorial misconduct. At least if we put that at issue, that what he is saying in his bad faith, it might give some more leverage over the prosecutor because he sees that you're willing to fight this and you've got the goods on him. He might be inclined to throw you an even better deal, and you can get it on your own without having to get the lawyer involved.
Right.
Legal advice. Yeah, definitely. That's what. So contact me off air, and I'll send it to you if you decide to do that, and we'll take it from there.
All right. Do you have any videos on the state being a victim?
That's a common one when they try if they do address the issue of whether there's a victim or not.
Right.
I focus on the first part of the case, which is the legal injury. The legal injury is that you violated their laws, and then, of course, then the damage is somehow they're saying that society, the state is damaged. If they can't show the legal injury, it doesn't matter how much damage there is. Okay?
Right.
They can't show it was because of you. So even if you can show damage, if you can't show the legal injury, it's not actionable. And because their legal injury is you violated the law, and because they don't have any evidence that the laws apply in the first place, and don't think that they have to prove that,
right,
it all falls.
Yeah.
That's the way I handle it.
My claim is I guess a so-called victimless crime.
I wouldn't actually use that as a defense. I would use as a defense that because unless you have a libertarian sitting on the bench who's actually going to follow through on his libertarian philosophy, he's not going to give a damn. He's going to enforce what he thinks is the law, as long as he believes and it's proven that the laws apply in the first place. So, well, I appreciate the call. We're at another break. Contact me off air. We'll get you that motion, okay? All right, appreciate the call. We're going to go to, we're almost at the end of the second hour. We'll be back in just a few moments with your calls. Don't go away. And those on YouTube, we're on a break for about... Yes, welcome back to the No State Project here on LRN.FM, the Liberty Radio Network, and streaming live, of course, on my YouTube channel, No State Project. My website, of course, is markstevens.net. And if you're being attacked by a bureaucrat, you do pretty good. We got a very good track record established. Got dozens and dozens of documentary proof of tickets, complaints, and assessments being tossed out. Everything from the IRS, the traffic stuff, drug cases. So check it out. Also, Government Indicted, the book has a full model that we discuss here on the show all the time, every week. So just want to point out before I take a call, someone is saying it's easy to sue a judge. No. See, even for the hearing impaired. No. And you're going to have to provide a citation to show that that's true. I know what the law is here. A judge has absolute immunity if he started with jurisdiction. He does not lose absolute immunity if he exceeds his jurisdiction. For some reason, they get the Supreme Court because they're judges. Even if he exceeds, if he had jurisdiction and then exceeded it, absolute. So you're going to have to, hey, if I'm wrong, I will be the first to shout it from the rooftop. Mike, you have to provide documentary proof, because if you sued a judge or you know someone who sued a judge, there will be a court record. You're going to have to provide the court documents. Okay, a violation of the oath of office has nothing to do with jurisdiction. Fine. You're saying you sued a judge or that someone has successfully sued a judge and it's easy. I'm not okay, the dispute is that you're saying it's easy to sue a judge. I'm saying, no, it's not. Even if you've got the goods on him, his fellow judges don't let it go. That's why Ken Anderson was the Texas judge, went to jail for less than 10 days after putting an innocent man in jail for murder he didn't commit for 25 years. There was such a public hour, they had to do something. 10 days for 25 years? Come on. You're going to have to provide citations. You removed a judge's buddy. Okay, Mike, you're going to have to provide the proof. I'd love to see it. And if you do mail something, please scan it or send me the citations. Don't send me hard copies. Yeah, here I actually agree with Foreign Source. You can file the paperwork, but the case goes nowhere. Well, I would say dismissed. If you file against the judge, it is almost certain it's going to be tossed out immediately, and you're probably going to have sanctions against you. So I'm going to have to see the proof. Okay. He's been on the show before. We've got Home Bumming It from California. Welcome back.
Oh, man. I got stories.
You got stories?
So I went, they questioned my competency. I went to two different doctors. They couldn't, I went back to court after two doctors. They go ahead and they tell me, oh, we want you to see a third doctor. And so I asked them, what facts and evidence is the court relying on to harass me like this or to continue this on me? And they went ahead and they decided that I was competent. I actually had a body cam that I went ahead and made a video of while I was there in court. So, that's on BitChute though. I went back to court after, I went ahead and I filed a motion to recuse the judge after that. And they gave me this other judge, this old guy, who couldn't hear anything that I was saying, even through the PA system. He couldn't hear anything I was saying. He only heard bar members.
So did they? Now, is this because they had a better mic, or I mean, were they any louder than you were?
Oh no, they didn't have a mic. They weren't louder than me. The PA system was working better than it ever had before in that court. The judge was old and didn't want to hear anything except for bar members. So, yeah, I went ahead and I asked him if I had a right to a fair and meaningful hearing. He said, no, this is a pretrial, hearing. You have, that's for trial. That's what trial is for.
Pre-trial hearing doesn't have to be fair?
No, it doesn't. It's not fair or meaningful. It has nothing to do with anything. They're just wasting my time. I saw another lawyer in there that was on his own thing that I know from outside, and I showed him the charges and stuff, and I told him, I'm like, look, they haven't even given me any Brady materials, and he's like, you gotta file some sort of a request or something like that. I don't know what it was.
Yeah, which you
so
did.
I don't know if I had to put an amendment. What was that?
Didn't you file the Brady request?
Well, yeah, that was like one of the first things I did was I filed the demurs and the Brady request.
Okay.
And yeah, they haven't given me any Brady materials. They haven't told me who the name of the security guard was that hit me in the head. They haven't done any of that. So this was the time before last that I was in front of the older judge who couldn't hear anything unless you had unless you were a bar member, and he just outright denied me any fair, meaningful hearing whatsoever, and they wanted me to take a Faretta waiver or a public pretender, and I went with the Faretta waiver. Granted, I never signed anything, but the public pretender that was there went ahead and suggested to the judge that I just verbally agree to understand. So I went ahead and I just want this over with, man. It's been like a year now. And I went ahead and I took the Faretta waiver. Since I wasn't getting a fair, meaningful hearing, I mean, literally, he told me that.
Okay, well, let me ask you this.
3 times.
Since it's been over a year, at any time did you waive your right to a speedy trial?
No, but by them going ahead, and it hasn't been over a year. It's almost a year. April 16th will be the year date.
Okay, but that's not the time frame for a denial of a speedy trial. It's usually 180 days. So,
well, I found out from going through the competency hearings that my right to a speedy trial is suspended once they do that. So I didn't have a right to a speedy trial or anything at that point.
Right.
After that happened, they told me they had till the 4th of next month. But listen to this. So I go to court this last time, and I'm like, they go ahead and they bring out this, I don't know, he's a special, he's the supervisor at the DA's office, and they brought him special in just to talk to me, to offer me a deal of, just plead guilty to trespassing. Just plead guilty to trespassing, and will you could go ahead and pay the court fees. And I just kind of looked at it and I said, is that in U.S. dollars? And he said, yes. I'm like, well, I don't have any of those. So
Okay, well,
I said, when are we going to go ahead? When does jury selection start? And he goes, 3 to 5 days. I get back. This is outside of court. By the way, I recorded everything. They always go ahead and they threaten you with Penal Code 632, which is the wiretapping law out here. But if you look at Penal Code 632C, it states very clearly that in public hearings or in public locations, there's no reasonable expectation of privacy, and therefore it does not apply. 632 does not apply to courts in California. So feel free to record anything as long as you're not in.
Well, hold on a second there, Home Bum. We'll finish in the next segment. We'll be back here on the No State Project in just a few moments, and we got a full boat of calls. I'm not going to get the number out, so hopefully we were able to get to everybody in the next hour. And for those on the YouTube feed, we got about 5-6 minutes, so we'll be on a break. So stick around. Yes, welcome back to the No State Project live for this third hour of Anarchy Radio here from the Fortified Compound in Mesa, Arizona. And before I get to the calls, and we're running low on time, the TORE, T-O-R-E court, not a damn thing on Google, nothing on YouTube, nobody's ever heard of this. And who are we filing complaints against anyway? We're not typically filing complaints. If we're going to file a complaint, it'll be against the insurance, but we want things thrown out. Mike, you're going to have to something. And just send a link. There's got to be some information available about this. Give me an address of this place, something, because I mean, I'll look at proof, but you send me a link or something. My email address is on the website. You can scan and send me documents. So I don't know what the hell is. And a big hello to someone who just posted that they're watching and listening from Poland. So very nice. All right, we got Home bumming it back. Okay, so where were we, Home?
Well, let's see. I went through competency hearing.
Well, all right, we have that. We have. Let me. What I wanted to jump to was, I think because like New York has a thing where sometimes are suspended because of they don't count towards the speed trial. Let's say if there's an appeal or something like that done, maybe you still have it's still past the speedy trial if you exclude all the time that they took against your consent to do these competency evaluations.
Oh, that reminds me. Yeah, that's a good point. But that reminds me, two. Hey, come on, guys, knock it off.
Limited time.
The DA went ahead and he told me it was going to be 3 to 5 days before we get to jury selection. And then when I get back into court, they ask for a continuance all the way to the 30th, and I'm objecting the whole time. I mean, they offered me a deal where if I went ahead and I pleaded guilty to trespassing at the store, that, I'd only have to pay court fees. And I told him, well, I don't have, I asked him if it was U.S. dollars. He said, yeah. I said, well, I don't have any U.S. dollars. He says, well, I said, you could drop it. And he goes, well, we never do that. That's not how it works.
Well, if you have no evidence, that's the way it's supposed to work. So, okay. So we got to be quick. I got a full line of calls. So, and we got a lot of background noise, but the dogs.
So, well, okay. So now I'm like stuck until the 30th. There's, I'm not given fair and meaningful hearings. The judge told me that he asked me, he says, well, why do you want to plead guilty? I'm like, to resolve the issue. And I can see you talking, but I can't hear you.
There's a delay with that. You're live on the phone with, on the line with me now. Don't watch the video.
Right. So I went ahead and he wouldn't take a guilty plea from me. He said, I told him I wanted to resolve the issue, and he says, well, that's not a good reason to plead guilty. I mean, 98% of all the
complaints. Yeah, I'm sorry. It's just that I'm very short on time, and we need to move quickly. Obviously, when they're saying, why do you want to plead guilty? Say, look, if they have evidence that these laws apply, there's no reason to go to trial. The only reason why they think I did something wrong is because of their code. And if there's no evidence the code applies, there's nothing. But if there is evidence the code applies, well, then it doesn't make sense to tie up court resources. That's Hey,
right.
I don't want to waste precious judicial resources on such a minor issue.
Right. Well, you'd think that he would go ahead and be all like, oh, you want to resolve this? That's a great idea. Yeah. Let's get this over with. But they wouldn't even take my guilty plea this last time.
Yeah.
So I'm just they went ahead and they gave me this BS deal, and I told them, look, last time I was here, the judge told me that I couldn't plead guilty just to resolve the issue, so I'm not going to be able to take your deals anymore. And that was it. They don't have any evidence I did anything. They don't have, and it was like when the prosecutor, the DA, supervising DA went into court and he saw the charges. He smiled. He had this big grin on his face, like, oh my God, I can't believe this. We're on the hook for trial. And he doesn't even have we don't have any good cases against him. So I'm just like, I'm so fed up with the whole thing.
I understand. Well, have you filed a motion to dismiss for prosecutorial misconduct?
No, I have not.
I can get that to you off air, and what I would do is I would look at I would exclude the days, where they were doing something and it wasn't because you wanted it, and I would see how many days it is with that excluded, and if it's past the 180 days, file the motion to dismiss for denial of speedy trial, and that might just be what the judge needs to get this thing off the docket, all right?
Well, I know that's what, but I know that they only had 6 more days from the time that they went ahead and questioned my competency to actually find me guilty. So all of a sudden they got another 2 months or something like that, magically. And I'm like, what the hell?
Yeah, they probably don't. I would get that motion filed, make it a part of the record, and have them try to argue it to the contrary. So I got to go.
Well, keep your eye on your email. I'll get a hold of you through that.
Okay, sounds good. We'll talk to you soon. Appreciate the call. Home bumming it in California. We've got, the time's going fast today. We've got, I think I know who it is, but I can't. Area code 602. You're live on the No State Project. Which name? Where are you calling from?
Hey, Mark. I'm going to say this is Lady Tech.
Lady Tech.
In Arizona. Yeah, Mark. It's been a couple years since we talked.
Well, what can we do for you today?
In Avondale.
Okay.
Yeah, you talked to Huffner, the prosecuting attorney out there.
Oh, I spoke with one of the prosecutors with you?
Yeah, you did. Yeah, Huffner out in Avondale.
Okay, it sounds vaguely familiar. I'm sorry, but it's been a long week. Okay, so what's going on now?
Well, actually, I just want to update you on, because that was years ago, I want to update you on what actually occurred, just to kind of let your listeners understand that they're right on point by listening to what you have to say. You guys need to research this stuff on your own, because what Mark started with making a simple call to my prosecutor on a traffic charge opened up a huge world of research for me, and I'm to the point where, Mark, I walk in there now They look in the record, they get rid of the case, and they leave me alone.
Really?
And I don't know if you remember this. I'm the lady that you would always tell, oh, that sovereign garbage doesn't work. You used to always tell me that on your show. But what I did is I still followed your foundation of what you taught me on the principles of what's really going on. And I use them, and the issues just, it's hilarious now.
Why would
you? When I walked into court, and now they freak out when they hear I'm coming. So I want to thank you for that, Mark.
I appreciate that. Hopefully, I would still suggest that you drop the sovereign freedom stuff. Up again. All right, just hold on a second. I know you probably can't hear me. We'll be back here on the No State Project with Lady Tech in Avondale, Arizona, in just a few moments. So don't go away. And I was still chatting on YouTube. So yeah. All right, we'll be right back. Welcome back. You're listening to the No State Project here on LRN-FM, the Liberty Radio Network. And Mike is saying he sent this to me before. If it's true and I did see it, then obviously it wasn't compelling enough to make your case. The idea of a tour court, I think I'd remember that. Okay, I'll take a look at it again. But we'll get back to Lady Tech in Avondale. So why exactly are you continuing with the sovereign stuff and also using my work? Because my work doesn't really mesh with that.
Look, Mark, that's where you're wrong. I listen to you.
Well,
the sovereignty aspect of what I do in court is something I don't use anymore. But what I do find with your court script and the way that the questions are set up and your motion to dismiss is that you essentially are backing them into the corner.
Yeah.
You don't leave them out. I mean, as far as what the books say, but they go ahead and they do what they want to do, regardless. They run people over. They do things like that. So what I did is I just put a little more research into your aspects and listen to the things that you were saying. And I said, okay, I can back them into the corner because of their oath. I can do other certain things, you know what I mean, to bring to light the fact that they're not even following their own rules.
Why would you have to go and use sovereign citizen type of arguments in order to do that? I mean,
that's the whole thing. I don't use sovereign citizen type arguments anymore. And that's why I want to thank you so much. You know what I mean? I really don't even like to deal with their statutes at all if I don't have to. But there's a lot of people that are trying to find their way and trying to figure out what's going on with court. And if you don't understand jurisdiction, you're not going to be able to catch everything else. You see what I mean? And once I understood jurisdiction, even though they kept running me over and stuff was happening to go to appeals and things like that, there were just other avenues that I added into. Okay, you guys want to do that? Okay, we're going to do this. We're going to set this in place, because what I found is that when you put the spotlight on the judge, she's basically not having their documents located in the proper location, their feet are held to the fire. They're going to straighten up, because what I hear with a lot of the people that were calling in, it's that they will continue. They will run you over. It doesn't matter. It does matter, but you just have to put the pieces in place that are going to hold your situation together. It's about principle, and it's about a record. That's what I learned from you.
I'm glad I was able to do that. Do you have any documents to show that tickets have been thrown out?
Almost all my stuff gets thrown out in one way or another. I can show you where the last time I went in front of Alan Kuffner, which was not that long ago, he basically suspended the sentence they gave me on supervised probation just because they were supposed to go to trial with me that day. And then a judge from another city that same day ended up looking in the record and seeing a bond in the record. So he notified Kuffner to get rid of the case.
How do you know he notified? But how do you know that happened? How do you know the one judge notified the other judge?
Well, I can, because they're kind of working together on me over here. I don't know if you remember. You really don't. We would have to like talk, update about. I'd have to bring it back to your remembrance because it was a while ago. It was a couple of years ago. But what happened when you were working with my situation, as far as jurisdiction, your jurisdictional question caused almost everybody in the city that had authority to leave. So I retired the judge. After you talked to Kuffner, I retired the judge. After the judge retired, I retired the city manager. After the city manager retired, the mayor left.
All right, we're going to have to spend. You're going to have to call another show so we can go into a little more detail about about how why you're saying that's true. I just have way too many calls right now and very little time.
This is what I'm going to do. This is funny. I have my Frank Rizzo sweatshirt on today, and I just happened to see your live stream. So I'm going to send you a picture of me in my Frank Rizzo t-shirt, chilling in Arizona to your cell phone. And I'll talk to you later on, Mark.
Cool.
I really appreciate
that. Yes, definitely call back.
All right.
Lady Tech in Avondale. Yeah, I have to pull up that call with that prosecutor. But we're going to do our best to get to as many people as possible. So I appreciate everyone's patience. But we have area code 518. I think that's New York. But you're live on the No State Project. What's your name? Where are you calling from?
Hey, Mr. Mark Antoine, man. I spoke with you briefly. You sent me a motion to help me in this traffic ticket case. I sent it out to the DA as you requested, as I requested your help. They sent some frivolous response back in regards to the motion. As far as right now, I haven't heard anything from them, and it's been maybe almost a month. We challenged the jurisdiction. We challenged discovery. I think that they was just babbling on about that they had jurisdiction.
Okay, but they didn't provide any actual proof. You said, right?
No, they actually didn't provide anything. What they did was they sent a letter back. I actually sent it to you via email. I'm not sure if you quite remember, not too long ago. It's probably a month ago. And in regards to the letter, I can briefly go through it with you if you have the time. In regards to the letter, it was basically stating that they was asking the judge to deny the motion that I sent in to them.
And did they have any evidence that they referenced or cited in the record that would overcome the motion?
Hold on one second. As far as what they did give and state, as I had documented and I sent to you, you said they was just basically babbling. As I've read it, it looked as if it was babbling to me also. I've been trying to do more research and get a better understanding of what your wisdom and indications of how to attack them and how to address things in an appropriate manner. But as of yet, I haven't heard anything back from them from the motion that they sent.
So the judge. Let me put you on hold there a second there, Angelo. We'll be back. Wow. We'll be back here on the No State Project just a few minutes, talking with Angelo in New York about traffic. And it reminded me, I'll talk about another. I had a judge say that the motion was incoherent, which is nice. To be able to prove bad faith. We'll discuss that when we get back in just a moment. We're back here on the No State Project. Let's get right to it. We only have a couple of segments left. We're going to get back with Angelo in New York. All right, so Angelo, just trying to jump back into this. If they haven't responded in so many days, what I would do is file a motion to dismiss for prosecutorial misconduct that they obviously are, proceeding and they're knowingly proceeding absent evidence of personal and subject matter jurisdiction.
Okay. So what I was waiting, they did send a response back, which I sent the reply to you, and he was basically saying, as I have had it before here for you, that the motion that they do have jurisdiction, that they did have jurisdiction, and that they was filing a motion in response to what we sent in. But as of yet, I still have heard nothing from them.
And you haven't gotten a formal response from the judge regarding the motion, whether it's been...
Nope, I haven't gotten nothing from the judge, and that's what I'm waiting after you get the motion that you gave me. I sent in already.
Well, I would put more heat on the prosecutor by filing to dismiss for prosecutorial misconduct and add that to the list.
Okay, so what I'm going to do is I'm going to go to the site, and I'm definitely going to need the motion in regards to that.
Well, just contact me by email. Remind me after the show, and I'll send you the template. It does have to be edited to reflect your position. Somebody actually just took it and filed it with no editing, and I wrote it regarding what was happening in Concord, over there in Concord, Massachusetts, with Tiffany Castillo, and he left all that in. It has to be edited. It's just a template. Some of the legal
I edited everything out. I can send you a copy of the motion that I edited. That you sent me. Everything was edited out in the manner how you emailed me.
Okay. All right.
So that I just haven't received the response from the judge after the district attorney already responded.
Right. So what I would do is I would file as my response would be a motion to dismiss for prosecutorial misconduct and put in there that he's not responding. It's not a responsive answer. He doesn't have any evidence to overcome it, and he's not providing any discovery.
And right, he hasn't provided yet, because when it says on it, do you have anything via audio, or did I say anything? He states no.
Yeah, and you haven't got it. They have not presenting the evidence to overcome the motion, and they're not presenting the evidence, of course, to comply with the discovery and Brady request.
Right. Okay, because I said when I was there, I asked him, I said, okay, aren't the cops required to carry audio, video, surveillance, some type of something, and you mean to tell me you have nothing? And so after I asked him that, I have no response from the judge as of yet, and that's been over a month.
Yeah. Put that in obviously that's something for the Brady request, that they're not providing that information for you. And you have a possible destruction of evidence. That happens all the time. Where the body cam didn't work at just this critical time. Could you imagine if you had, if you had evidence, video evidence, and you try to tell them, oh, well, it didn't work. They'd throw you in jail for destruction of evidence and obstruction. But we know they get away with it all the time. So, yeah, email me after the show, and I'll get you the copy of that template.
Okay, and I got you, and I thank you for your appreciation and your love and support to all that you've helped, man. You're a big help to a lot, and they just don't realize it.
I think people do appreciate it, and I do appreciate the sentiments and the call. And so I'll get with you off air.
Okay, man. You have a blessed night, and thank you again.
You too. Appreciate it. Angelo in New York. We're going to go I think I know who this is. We have Mike in Northern California.
Hello, Mark.
Mike, how's it going?
Oh, not bad. Not bad, actually. I received this letter a while back. Actually, I think it's dated 1/2/2019. And I sent a copy of it to you, but I don't know if you've actually received it. It was kind of weird the way I had to do it. I sent it through a third party, and, well, the third party sent it to me, and it has my name in the box there. And so I just was able to forward it to you, so I'm not sure if you saw it. But,
I think
I just wanted to...
I believe I remember seeing that. We had some email contact about that, didn't we?
Oh, it's been a while, yes.
Well, I think what they're doing, your situation is a bit different than the other Mike I'm working with in California who's been on the show a number of times, in that, you're not, this is a property tax issue for those who aren't aware, and you're not, you haven't paid. We've asked for the evidence, they haven't backed it up, and they just want to continue billing you until they may want to escalate that. That's why I said, the only other option we have, if they're not getting, because I think you have to pay it to get the hearing, which really sucks.
I'm sorry, say again? Have to pay to do what?
I think in order to get a hearing, you have to you have to pay their demand first. So they're not going to give you a hearing unless you pay it. Now, I can go through and look to see if you could file an appeal with the Board of Tax Appeals. I have to do that in this other case too, because even though he paid, they gave him, he paid to get a hearing. He actually paid the filing fee to get it, and they won't give him a hearing. So, we can't go to court yet. We have to go to the Board of Tax Appeals first and exhaust state remedy. So you have to remind me in an email, hey, check to see if we can file, an appeal of this assessment with the Board of Tax Appeals prior to making any kind of payment. And, if not, then we're kind of stuck.
Okay, well, may I read a couple of lines of this for you, maybe just to jog your memory a little bit? If it's been a long time, so it might be a little foggy for you. Sorry about that if I sounded
That's okay.
bad about that.
Just, let's keep it brief.
I'm sorry?
I was just too late. I was saying keep it brief.
Oh, okay. All right, real quick. Property information, and it has assessment number, fee number, location, and lien date owner, and then it has my name. And it says, as of January 2, 2019, our records indicate that the following current year taxes are unpaid. Please disregard this notice if payment was already made. However, if you feel that this notice is an error, please contact our office as soon as possible so that we may research the payment.
Well, I think that's, it's basically what they've already sent you before. Is that language is already on the previous ones when we did make calls.
Okay. Well,
What we can do is we can set an appointment so Monday or Tuesday of this coming week, we can make some more calls, see if we can get somewhere, maybe a little further than we did before.
that would be good. That would be good, and we'll go from there.
Yeah, contact me on the email. We'll set something up for Monday or Tuesday.
Very good. Thank you, Mark.
Appreciate the call.
all your hard work and your help. Thank you.
Yeah, you're welcome. There you go. Say, okay, well, Mark won't agree to terms. Hey, if someone sends me the proof, and I'll do this on the Wednesday show, I'll present the documents and, I'll read them. And if what Mike is saying is true, I will change my opinions. My opinions should and do conform to the facts. So, yeah, I'll do that. I mean, that's the show is about the evidence and going based on the evidence. So, yeah, not a problem. Well, we'll be back in just a moment. Just welcome back to the No State Project. And maybe it wasn't heard before, but just to let Mike know, if he wants to send me the documents again, apparently, I'll talk about it, present it on the Wednesday broadcast. And if they have proof of what you're saying, that there is actually a Torah court and you can get judges removed and all what you're saying is true, yeah, of course I'll accept that. The opinion should conform to the facts, to the evidence. I'm not a statist. I don't give a damn what judges say here. My reality isn't dictated by what a lawyer says. I've changed my mind on things. I've been wrong, and I move on, and and my map of the world changes. So, yeah, I look at the evidence. I don't just say that. And for anyone who thinks that this little tiny YouTube channel is monetized. It's not. And it's really easy to see. It is not monetized. There is a couple of videos that are out there because my daughter was listening to some music that was picked up by the microphone, and it was not because I did it. It was a copyright strike. And so what they do is they monetize that video. But none of my videos are actually monetized by me. So, and anyone thinking I'm making money doing this, you're out of your mind. I barely keep a roof over my head. So, anyway, let's get to the last call. I'll probably only take one more call. So if I miss you, I will be live on the Wednesday broadcast. That's commercial free, so we get a lot more people, a lot more dialogue there. So we have area code 509. You're live on the No State Project. What's your name? Where are you calling from?
Hi, this is Joshua out of Washington State.
John from Washington. What do you have for us today?
Joshua.
Oh, Joshua. I'm sorry.
How's it going?
Pretty good.
Yeah, you got this crazy troll on there making wild claims you can't seem to provide a link to. I love those guys. Anyways,
I think it's telling that there's not a damn thing on Google about it, and I don't think it's some kind of Google. And other people were using different search engines. There is absolutely nothing for Tor court. There are no.
Yeah, I've never heard of that.
I never heard of it. And the idea that it's easy to remove judges or like to sue them. Nope. I just...
Yeah, if that were the case, we would do it every day, all day long. We'd get rid of cops, judges, and all these corrupt officials that pretend to be protecting and maintaining our rights while they're running around rampant, racketeering, and just doing whatever the heck they want, killing, murdering, throwing people in prison. I mean, if I were to do that, I tell you, the whole town would probably kill me.
As they should.
Right. Criminal activity is not good. So, anyways, I had a quick question. I've been following you for quite some time. I'm known as Heretic on YouTube.
Oh,
and
cool.
So I'm still learning this stuff. I have an understanding, but I haven't really ever learned how to apply it properly and how to stand my ground in court. And this year is the year Heretic's gonna definitely win. My girlfriend last year won just by filing a motion to dismiss. And so anyways, I went to court on the 7th, and there was no prosecutor in the room. And the judge was doing his thing and said that they had probable cause. And I objected to that. And he said, well, you can't object in this hearing. This is not that kind of a hearing. The prosecutor's not here. You can't make an objection. And the first thing that came to my mind was, well, then who's bringing the charges? So it sounds like the judge is prosecuting from the bench. So when I went home, I wrote up in a notice of objections and applicable issues, and I filed that objecting to one, there not being a corpus delicti, yada, 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 and the fact that the judge was prosecuting from the bench, and there are no facts and evidence to prove. I think I had like 5 or 6 objections.
But the thing here, but Josh, he's lying, saying that you can't object. That's absolutely not true. The fact, just because the prosecutor isn't there, doesn't mean that if the judge is doing something unfair, that you can't object to preserve that issue for appeal if you have to appeal it. So I would put in there that he lied, saying you couldn't object. That's ridiculous.
Yeah, and that violates your due process.
Yeah.
And so it was like. So I put that in my objection paper.
Can't object.
And now I got court again on Thursday, and I was going to bring that up with the next judge. Because they're playing musical judges. So, what do you think about this, not having a prosecutor in the room? Like, who's bringing the charges if there is no plaintiff?
Well, it depends on what kind of situation it is, whether the prosecutor is required to be there. I don't think in minor cases that they're required to be there for an arraignment. So,
well, the driving while license suspended, and that's a crime in this state.
Yeah, but it's a minor. It's not a felony. It's a minor thing. So I would, obviously the case, it's easy to see who's bringing it. A police officer, wrote a ticket and the prosecutor filed it. But do they have to be there for that particular? Probably not, because it's minor. Do they have to be there for other proceedings? Well, yeah, absolutely. For a pretrial conference, they have to be there. The judge doesn't have to be there, but the prosecutor has to be there. Do they have to be there for trial? Yeah. Or someone is supposed to be there prosecuting, whether it's a formal prosecutor's office or someone from the police department, like they do in New Hampshire.
Okay, so the only time you have to be able to face your accuser is at trial. Is that correct?
Well, at a pretrial conference, I think they should be there for an arraignment. But if they're not there to defend themselves, that's their fault. That's not your fault. And look, and bottom line is, when you're in there, everything that the prosecutor is relying on should be in that file for the judge anyway, especially when we're dealing with, things like traffic. It's not like a murder trial where you've got, actual evidence. If it's not in the file when the judge calls the case, whether the prosecutor is there or not, the judge should throw it out. There's nothing for the prosecution to argue at that point. The judge just has to go and look at the file. So if it's not there, all right, well, the prosecution's sleeping on the job. They're not here to defend their case, prosecute their case. I don't see the evidence. We're going to have to throw it out. If the prosecutor has a problem with that, let him refile with the actual proof.
Right. Well, the judge said that I was not allowed to make any objections because the prosecutor wasn't there.
That's
and
ridiculous.
I wanted to,
No. Even in a situation where the prosecutor is not legally required to be there, you have to object to preserve the issue for appeal. So if the judge is the idea, like, what is it in his head? If the prosecutor's there, it's impossible for him to violate due process? Give me a break. Please. I'm not getting, you know what you could do? You could say, well, no objection. Can you cite that? Where is it saying where is that legal? Where's the legal citation and authority to say that just because the prosecutor decided not to show up, I can't object? Come on. The hell are you talking about?
Being that he wouldn't let me make an objection, where does that leave us?
He's lying.
They pretty much lost, right?
Well, not yet, but obviously the writing's on the wall. If you got a judge who's willing to lie and say you can't object just because the prosecutor's not there, I'm objecting to what you're doing, jackass, not what the prosecutor's doing. Well, at this particular time.
Right. Well, he said he had probable cause. In other words, he said he had jurisdiction, and I went to object, and he said, well, you can't object. And I was like, oh, it doesn't make sense. And then they wanted me to waive my right to counsel, and like whatever those waivers are, you have to sign to represent yourself. None of it makes any sense.
Well, it makes sense because he was just railroading you. He didn't want you to have the opportunity to defend yourself. One of the basic tools you have to defend yourself is to make an objection. That is part of any kind of fair proceeding, is that you can object. That is the legal tool that you use to call out unfair actions and behaviors by the other actors, and the judge and the prosecutor. So I think it's just a blatant denial of due process, that he's hamstringing your right or your ability to defend yourself. No, due process requires notice and opportunity to defend, and if you can't make an objection, you can't adequately defend yourself. I mean, it's as simple as it gets, right?
So I didn't bring that up in that manner at that time. Do I bring that up on Thursday?
Yeah. Absolutely. We're out of time, so I'm really sorry. We'll have to get with you off air, Joshua in Washington. This has been the No Stay Project for January 26, 2019. Whoever we missed today, we will get you on the Wednesday broadcast, which of course is commercial free. So till next time, salud.